Ready, start. Appelant is a non-resident company incorporated in France and is engaged in oil drilling activities. In 1983, the Appelant was awarded a 10-year contract for drilling operations in offshore Mumbai from 1983 till 1993. Thereafter, the Appelant was awarded another drilling contract in October 1998, which came to be formalized in January 1999. In the interregnum, that is, during the relevant assessment years, though no drilling contract was awarded, the appellant carried on business correspondences with ONGC from its office at Dubai and headquarters at France and had also submitted a bid for oil exploration in 1996. During this period, appellant undertook various expenditures, including administrative charges, audit fees, etc., with the intention of carrying out its business activities as well as realizing tax refunds from the income tax department. The appellant filed its return showing single inverted comma nil single inverted comma close income. The assessing officer disallowed deduction of business expenditure as well as carry forward of unabsorbed depreciation on the ground that the appellant was not carrying on any business during the relevant assessment years. The findings of the AO were upheld by CIT within bracket appeals bracket close. In the present case, undoubtedly, after 1992-93, the assessee did not have any business activity. However, there is enough evidence on record to suggest that the assessee had not completely gone out of business. Copies of correspondence dated 1996 with ONGC show that the assessee was in constant touch with ONGC for supply of manpower in respect of expert key personnel for deep water drilling, and a tender in this regard was in fact submitted in September 1996. This proves that even after the completion of the earlier contract in 1993, the assessee was contemplating to bid for another contract. The efforts of the assessee finally culminated in a firm contract being awarded to it in 1998, which was formalized in 1999. A copy of the said contract is on record as held by the Bombay High Court in the case of Hindustan Chemical Works Limited versus CIT in 124 ITR 561. There is a marked distinction between double inverted comma lull in business, double inverted comma close, and double inverted comma going out of business, double inverted comma close. A temporary discontinuance of business may, in certain circumstances, give rise to an inference that a business is going through a lean period of transition and it could be revived if proper circumstances arise. In the present case, the period between 1993 and 1998 was of such temporary discontinuance only, which can be termed as a double inverted comma lull in business double inverted comma close. Thus, when the intention of the assessee was never to go completely out of business, it cannot be concluded that the assessee had discontinued its business. To our mind, it makes no difference if the correspondence was by the Dubai office of the assessee or by its office in France, as was one of the contentions of the learned DR. In fact, in the accounting year 1995-96, the assessee had also paid consultancy charges to follow up the aforesaid ONGC bid. Further, the receipts from this contract were offered for taxation in assessment year 2000-03.